have a PowerPoint that's hopefully a bit educational. I'm just going to share my screen here so your viewers can follow along. My office focuses mainly on real estate litigation. A big part of that is landlord-tenant law. We also do some business litigation as well, but the primary focus is trying to represent and advance the interests of landlords, your members. So let's dive in. Topic is death in a unit. What California housing providers need to know about various aspects of situations where a tenant dies in a particular unit. What I want to start out with is a distinction between a situation where you have a death where the deceased tenant is the only resident in the unit, because that's going to have an impact. If one person dies and they're the only occupant versus one person dying and there's other occupants. So if you have a situation, you landlords out there, where the tenant is the only sole occupant, and that person unfortunately passes away in the unit, there's certain things that you should be aware of. And there's a further distinction between whether the tenancy is in the middle of a term. In other words, if you executed a lease agreement with the tenant and you're in the middle of that 1-year term, versus a situation where the tenant is on a month-to-month. It's actually a pretty big distinction. Now, if the tenant passes away in the unit and the tenancy is a month-to-month tenancy, it actually automatically results in the termination of the landlord-tenant relationship. There is no longer a tenant on the other side of the contract to perform obligations or to withhold possession of the property. The most important aspects that you should be aware of if there is a sole deceased tenant in the unit and it's a month-to-month situation is that the tenant's estate has no claim to possession. The tenant's children and heirs have no claim to possession. And this also applies to rent control properties. And I'll tell you how it's come up in my practice. I've had situations, of course, most of my clients own properties that are RSO properties, that are rent stabilized properties. And those are valuable to the tenants, right? Because the rental values are depressed. And what I've seen is the person passes away and all of a sudden a cousin or a third child or a mother or a father of the deceased comes out of the woodworks and tries to access the property and tries to gain possession. And they do so they can fall into the low rents under the RSO. There is no legal obligation for the landlord in that type of situation where the sole tenant who occupies the property has passed away for there to be any continuance of the landlord-tenant relationship. None whatsoever. If you see other people trying to enter the unit to gain possession, you need to take immediate action to file an eviction action, because if those people come in and somehow you start accepting rent, that's going to create a new tenancy situation with those family members. So if someone passes away on a month-to-month, that terminates the rental contract and any further obligations. Now, if the tenancy is not a month-to-month tenancy, that means if they're in the middle of a 1-year term and the tenant passes away, that does not automatically terminate the lease agreement or the landlord-tenant relationship. What happens is that the estate of the deceased person fills the shoes of the deceased tenant. Now, that doesn't mean a representative of the estate can come in and start living in the property. What that means, and it's actually a benefit for the landlord, the estate would continue having the monetary obligations under the lease agreement. So if there's 9 months left on the lease agreement and you're charging the tenant $3,000 a month, the estate has an obligation to continue paying for the duration of the period of the lease. Now, of course, the landlord has a mitigation obligation, which means once the tenant passes away and you regain possession, you have an obligation to try to re-rent the property in order to mitigate the damages for the estate. But you can actually go after the estate for the balance of the rental period. So that's the crux of what happens initially when the sole tenant passes away. Now, if the tenant is not the only tenant, in other words, there's other occupants in the unit. I'm sorry, before I start into that, these are actually on the slides what you'll see. These are steps that a landlord should avoid taking right when the tenant passes away. I've had situations where My client, who's a landlord, he has a deceased tenant, and the person unfortunately is wheeled out of the property in an ambulance or something like that. The landlord goes in and changes the locks immediately. Well, funny enough, that'll constitute an illegal eviction. You're not allowed to do that. The only time you can go in and reclaim possession is under one of three scenarios. Number one, the estate representative comes to you and says, we're removing any claim of possession that we have. They send you something in writing saying we're no longer interested in this property. The property is yours. In that event, you could go in, change the locks, and rent the property to somebody else. If there's no one to communicate with, which usually that's the case because you don't know if they have a trust or an estate representative or any family members, and 30 days has passed since the last time you received the rent payment, okay, you can issue a notice of belief of abandonment. Okay, that's available to you if the person has passed away. Now, of course, you can't mail the notice, you can't personally serve the notice of belief of abandonment because the tenant has passed away. So what you should do is fill out the notice of belief of abandonment and post it on the property. If you do that and you wait the requisite number of days, off the top of my head, I think it's 18 days, and you don't hear anything from anyone, at that point, you have authorization to go back, regain possession, and change the locks. Finally, you could file an eviction action and go to court and tell the judge and or jury that the tenant has passed away, and on those grounds, you're seeking to reclaim possession of the property. Do not go in there and change the locks immediately after the tenant passes away. All of a sudden, you're going to get hit with a lawsuit from a family member or an estate representative saying that you illegally evicted the deceased tenant. Don't do that. If the tenant is not the only tenant, if the deceased tenant is not the only tenant residing in the unit, the remaining tenancies continue without interruption. It's as though nothing has really changed. The one material aspect that may change is that the remaining tenants are going to be obligated to continue paying the full rent. They don't get a discount because one of the occupants has passed away. But for all other intents and purposes, the tenancy continues without interruption as though that tenant has not passed away. Now, personal property. I also see this come up a lot as well. You know, what do you do with the tenant's personal property if they pass away? Now, if you know they have an estate representative, an executor of the estate, you should make contact with that representative and arrange for them to come pick up the items. Okay. Now, if you're not aware of any representative or any family member, you can treat the property as abandoned, and you have to follow the notice of abandonment procedures and a notice to reclaim abandoned property. That's a notice on a piece of paper. You could probably find it on AOA's website as well, where you fill it out, and you cannot personally serve this on the tenant because the tenant has passed away. What you have to do is you have to post it on the property and wait the requisite number of days. If you don't hear anything from anybody, you're free to dispose of the personal property if the personal property is less than $700. Okay, if it's less than $700, you can just junk it. If you reasonably believe that the property is more than $700, for instance, if they have, I don't know, expensive bicycles or computers or furniture, you know, gold, cash, so on and so forth, what you're actually obligated to do is you have to auction. I know it sounds crazy, but you have to auction the personal property off. You can deduct the expenses you've absorbed to facilitate that auction, and you take the differential and you have to pay it to the state of California. Okay. So if they have a bunch of expensive things, do not junk those expensive things because you're going to expose yourself to a lawsuit from the estate down the line. With respect to a security deposit, what do you do with the security deposit once the tenant passes away? The situation is conducted as though the tenant's tenancy has just terminated. You follow the same security deposit itemization requirements as you would in a situation of the tenant vacating the property. You go in there, you assess for damage. You know, if there's no money left over, you can actually bring a claim against the tenant's estate in probate in order to get your money. Most of the time, that's impractical, right? You're not going to go hire a lawyer to make a probate claim in order to get a couple $1,000s. Now, if there's money left over after the deduction, you have to issue the balance of the security deposit to the estate representative. If you don't, you could be on the hook for twice the amount of the security deposit amount under Civil Code Section 1950.5. So make sure you're accounting for the security deposit as though you would be under any other situation when a tenant vacates the property. Finally, what are your disclosure obligations? So suppose that the tenant passed away in the unit, you've regained possession, you changed the locks, and now you're marketing the property for re-rental. If the tenant passed away in the unit, and I'm talking about specifically in the unit, not in the common areas, not on the sidewalk, but in the unit, you have an obligation to disclose that death to any prospective tenant, any future tenant, for a period of 3 years after the death. Okay. So if you regain possession and it's been a couple months and you're trying to re-rent it out, you have an affirmative duty to disclose that death to any prospective tenant. After 3 years, you don't have any affirmative obligation to make the disclosure. But if a prospective tenant asks you about it, asks, hey, has anyone died in this property in the past? You have an obligation to be truthful. You can't conceal that fact because under California law, that fact is a material term, and you have to disclose all material terms to any prospective tenant. I think that's all I have on this subject. I hope you guys don't have situations where your tenants pass away, but if you do, hopefully the information I shared with you and we discussed today is helpful in helping you guide you through the process to reclaim possession and also your disclosure obligations.